The first thing I saw wasn't the torn paper.
It was the smile on her face. The president of the Willow Creek Estates HOA stood in the center of the county recorder's office lobby, holding the original deed to my family's ranch between perfectly manicured fingers. Cameras from half a dozen cell phones surrounded us as neighbors whispered and recorded every second. She looked straight into my eyes. "You've been lying to everyone," she announced loudly enough for the entire building to hear. "This property belongs to the homeowners association now." Before I could respond, she ripped the deed clean down the middle. The sound was surprisingly loud. "Rip!" Gasps echoed through the marble lobby. Someone muttered, "Oh my God." Another neighbor laughed. The HOA board members behind her applauded, as if they had just won a championship. "You don't own anything anymore," she said, letting the torn pieces flutter onto the polished floor. "Maybe next time you'll learn not to challenge people with real power." For several seconds, I simply stared at the shredded document. Not because I was afraid, not because she'd destroyed my claim, because I couldn't believe she had just committed the single biggest mistake of her life. In front of nearly 50 witnesses and multiple security cameras, my attorney, Daniel Whitmore, slowly bent down, carefully picked up every piece of the torn deed, and placed them into a large evidence envelope without saying a word. The room became strangely quiet. The HOA president tilted her head. "What?" she asked with a smug grin. "Planning to tape it back together?" Daniel looked at me instead. "You want me to say it?" he quietly said. I nodded once. He turned toward the crowd. "I suggest everyone keep recording." Confused murmurs spread through the lobby. The HOA vice president folded his arms. "Is that supposed to scare us?" Daniel smiled. "No." He reached into his briefcase and produced a leather credential wallet. "I simply think the public should witness what happens when someone destroys federally protected evidence during an active investigation." The smile disappeared from the HOA president's face. "What investigation?" she demanded. Daniel didn't answer. Instead, he looked at me again. For years, I had worked very hard to keep my professional life completely separate from my private one. My neighbors knew I traveled often. They knew I was an attorney. They assumed I handled complicated government cases. None of them knew the truth. I took one slow step forward. "My name," I said calmly, "is Jonathan Mercer." The lobby had become so silent, I could hear the air conditioning humming above us. "I serve as a United States District Judge." Every face around us froze. One board member actually dropped his phone. The HOA president blinked twice before forcing out an awkward laugh. "No." Her voice cracked. That's impossible." I reached into my jacket and quietly displayed my federal judicial identification. The county recorder, standing behind the counter, suddenly went pale. At that exact moment, the front doors swung open. 3 agents wearing dark jackets with gold federal badges walked inside. The lead agent scanned the room before locking eyes with me. "Your Honor," he said, "we've finished tracing the deed transfers." He held up a thick evidence folder. "And we've uncovered something far bigger than simple HOA corruption." The silence inside the recorder's office lasted only a heartbeat. After the federal agents walked in, everything became a blur of raised voices, flashing cameras, and confused questions. But before I explain why those agents were there, or how an HOA president ended up tearing apart a deed she had no legal right to touch, you need to understand who I was long before Willow Creek Estates ever knew my name. My name is Jonathan Mercer. I'm 53 years old, and for the last 11 years I've served as a United States District Judge. Federal judges spend their careers avoiding publicity. We don't campaign, we don't give interviews, and we certainly don't announce ourselves every time someone disagrees with us. That was exactly why none of my neighbors knew what I did. To them, I was simply the quiet guy at the end of Ridge Hollow Road. I preferred it that way. After decades of hearing criminal trials, constitutional disputes, fraud cases, and civil rights lawsuits, home was the one place where I wanted peace instead of conflict. The property itself had been in my family for nearly 80 years. My grandfather bought the original 42 acres in 1947 after returning from World War II. There wasn't much here back then, just rolling pasture, an aging red barn, and a modest farmhouse built with his own hands. My father expanded it over the years, planting rows of oak trees along the driveway, and digging a small fishing pond where my sister and I spent countless summer evenings trying to catch bass that always seemed smarter than we were. When my parents passed away within 18 months of each other, I inherited the land. Selling it never crossed my mind. Every fence post reminded me of my grandfather. Every creaking floorboard reminded me of my mother humming while she cooked breakfast. Every sunrise over the eastern field felt like a promise that some things in life were still worth protecting. By the time I retired to the property full-time between court sessions in Washington, suburban growth had swallowed nearly everything around us. Developers built Willow Creek estates on land bordering my ranch. At first, the new neighborhood seemed pleasant enough. Families waved while walking their dogs. Kids rode bicycles past my gate. Several neighbors even thanked me for preserving open space instead of selling to another developer. I kept to myself, but I wasn't unfriendly. Then little things started changing. One afternoon, I found bright orange survey stakes driven 20 feet inside my pasture. I assumed it was a contractor's mistake and pulled them out. 2 days later, they were back. This time, there were twice as many. A week later, I discovered fresh tire tracks crossing my private field, even though the entrance gate had been locked. When I checked the security cameras, the footage showed a white pickup truck entering through the service road just after dawn. The company logo on the driver's door had been covered with black tape. That wasn't an accident. Someone didn't want to be identified. A few days later, I opened my mailbox and found an envelope with no postage, no return address, and only my name written neatly across the front. Inside was a single sheet of paper. Across the top, in bold black letters, were 6 words that made my stomach tighten. Welcome to the HOA's jurisdiction. There was no signature, only one sentence underneath. Whether you join willingly or not. I read the note 3 times before folding it neatly and slipping it back into the envelope. Most people would have dismissed it as a prank. I couldn't. After decades on the federal bench, I'd learned that real intimidation rarely began with broken windows or shouted threats. It started with small, calculated acts designed to make you question yourself. A misplaced boundary marker, an anonymous letter, a stranger testing your reaction. Someone wanted me to feel watched. So instead of reacting, I did what I'd always done. I documented everything. I photographed the envelope, scanned the note, sealed both in an evidence bag from my home office, and wrote down the exact time I found it. 2 mornings later, the confrontation arrived. I was repairing a section of split-rail fence near the eastern pasture when 3 black SUVs rolled slowly up my private driveway without stopping at the closed gate. The lead vehicle nudged the gate open hard enough to bend one of the hinges. I set my hammer down. 6 people stepped out. At the front was a woman in her late 40s, wearing an immaculate navy blazer with a gold HOA badge pinned to the lapel. She carried a leather binder under one arm as though she were walking into a board meeting instead of trespassing. She smiled before she even reached me. "Mr. Mercer." I'm Victoria Langley, president of the Willow Creek Estates Homeowners Association. She extended her hand. I didn't take it. "You've entered private property." Her smile didn't move. "We're here to resolve a compliance issue." I glanced past her at the tire tracks cutting through my grass. "The compliance issue appears to be your vehicles." A few board members chuckled. Victoria ignored the comment. "As of this morning, your parcel has been incorporated into the Willow Creek Community Expansion Plan." I stared at her. "No, it hasn't." She opened her binder and produced several neatly printed documents. "According to our records, your property is subject to HOA governance effective immediately." I looked at the top page. It wasn't a county document. It wasn't recorded. It wasn't even formatted correctly. It looked like someone had downloaded a legal template from the internet. "I don't belong to your HOA." "You do now." "No." She took one deliberate step closer. "You'll receive architectural guidelines, landscaping requirements, parking regulations, and an assessment invoice totaling $28,400. I almost laughed. "I'm not paying you a penny." The warmth vanished from her face. "I was hoping you'd cooperate. I was hoping you'd leave." One of the board members, a broad-shouldered man named Rick Holloway, crossed his arms. "You know," he said, "every homeowner who's fought us eventually lost." "I doubt you've met every homeowner." Victoria closed her binder. "Mr. Mercer, refusing to comply will have consequences." "I've heard." She tilted her head. "You think because your family owned this land for decades you're above the rules?" "No," I replied evenly. "I think property law still exists." Her jaw tightened. Without another word, she pulled out her phone. "Call the sheriff." Rick grinned as he dialed. "You'll wish you hadn't made this difficult." 25 minutes later, A sheriff's deputy pulled into my driveway. Deputy Ethan Brooks climbed out, listened politely while Victoria insisted I was an uncooperative HOA resident, then asked to see the recorded declaration proving my property belonged to the association. Victoria handed him her binder. He flipped through every page, then looked up. "Ma'am, where's the recorded covenant?" Her confidence faltered for the first time. "It's pending. Pending isn't recorded." She tried another approach. "The county is processing it." Deputy Brooks handed the binder back. "Then, as of today, this gentleman isn't under your HOA." Rick stepped forward. "Are you refusing to enforce private community regulations?" "I'm refusing to enforce regulations that don't legally apply." Victoria's smile returned, but this time it looked forced. "This isn't over, Mr. Mercer. I never thought it was." As the SUVs drove away, Deputy Brooks lingered beside me. He lowered his voice. "I've answered 3 calls involving this HOA in the last month." "For what?" He glanced toward the road to make sure they were gone. "Boundary disputes, forged notices, people claiming documents disappeared from the county records office." My expression hardened. "Disappeared?" He nodded. "I don't know what they're doing." He paused before adding quietly, "But I think you're fighting something a whole lot bigger than an overbearing homeowners association." Deputy Brooks' words stayed with me long after his patrol car disappeared down Ridge Hollow Road. Documents disappeared from the county records office. That wasn't the kind of complaint you heard every day. It also wasn't something a deputy would casually invent. That evening I called the one person I trusted to tell me when my instincts were leading me in the wrong direction. Daniel Whitmore. We had known each other for nearly 20 years. Before entering private practice, Daniel had spent over a decade prosecuting complex financial crimes for the U.S. Attorney's Office. If there was a paper trail to follow, he could usually find it. The next morning, he arrived carrying 2 briefcases and a cardboard box filled with portable scanners. He looked around my front porch. "You weren't exaggerating." "I usually don't," he smiled. "Good, because I brought enough coffee for a long day." By noon, my dining room looked more like an investigative command center than a farmhouse. County plats, historic surveys, tax maps, property deeds dating back to the 1940s. Every document was spread across the oak table my father had built by hand. Daniel studied my original deed through a magnifier. "The legal description hasn't changed in 79 years. "I know. So why is the HOA acting like they own it?" "That's what we're about to find out." Instead of starting with my property, Daniel suggested something unexpected. "Let's examine the subdivision itself." Within an hour, we had downloaded every publicly available filing related to Willow Creek Estates. The development had been approved 12 years earlier. Its original boundaries stopped nearly half a mile short of my eastern fence. Everything appeared ordinary, until Daniel frowned. "That's strange." He pointed to an amendment recorded 4 months earlier. According to the filing, the subdivision had suddenly expanded, directly over my ranch, without my signature, without notice, without compensation, without any recorded easement. I leaned closer. "That can't be legal." "It isn't." He printed the amendment and placed it beside my original deed. The legal descriptions overlapped almost perfectly. Someone had literally attempted to redraw county property lines using a single recorded amendment. Daniel whispered, almost to himself, "Either this is the sloppiest fraud I've ever seen, or someone expected nobody to check." That afternoon, we drove to the county recorder's office. Margaret Ellis, the chief records supervisor, had known me professionally for years, but treated me no differently than any other citizen. She greeted us warmly. "What can I help you find?" Daniel slid the amendment across the counter. "We'd like the original submission packet." Margaret typed for nearly a minute, then frowned. "That's odd." "What is?" "The digital record says supporting documents exist." She clicked another screen. "But the scanned files are missing." "Missing?" She nodded. "The index shows 8 attachments." She turned the monitor toward us. "Survey certification, owner consent, boundary approval, engineering exhibits, notarized acknowledgements." Every one of them carried the same status. "File not found." Margaret's forehead creased. "I've never seen this before." "Could they have been deleted?" Daniel asked. She hesitated. "Not without administrative authorization." "Who has that authority?" She looked uncomfortable. "Very few people." Before leaving, Margaret disappeared into a restricted archive room. 10 minutes later, she returned, carrying a dusty storage box. "I wasn't supposed to find this," she admitted. Inside were backup microfilm copies from older recordings. She carefully loaded one reel into a reader. The original subdivision map appeared on the screen. Then another. Then another. Finally, she stopped. "Wait." Daniel and I stepped closer. The amendment currently listed in the county database wasn't the same amendment preserved on the archived microfilm. Someone had substituted an entirely different version after it had been officially recorded. The signatures had changed. The survey lines had changed. Even the notary seal was different. Daniel slowly removed his glasses. My God! I stared at the glowing screen. This isn't just HOA harassment. No. He looked directly at me. This is systematic document fraud inside a government recording system. Just then, Margaret's office phone rang. She answered, listened, her face drained of color. She slowly hung up and looked at us. That was the county administrator. She swallowed hard. He says I'm to stop helping you immediately and hand over every document you've requested to the HOA's attorney. Margaret didn't move. Her hand remained on the receiver, and for several seconds, the only sound in her office was the quiet hum of the microfilm reader. Daniel broke the silence first. Did he explain why? She shook her head slowly. No, he only said the matter had become politically sensitive. Her voice lowered, and that all future requests were to be routed through the HOA's legal counsel. I exchanged a glance with Daniel. That sentence alone told us more than the administrator intended. The HOA doesn't get to control public records, Daniel said evenly. I know, Margaret replied. That's why this doesn't make any sense. She looked around the office, then reached beneath her desk and pulled out a small external hard drive. I made nightly backups of the recording database for disaster recovery. It's not part of the official archive, but... She hesitated. If someone altered the files after they were recorded, the older versions should still be here. Daniel's eyes lit up. Can you verify the timestamps? Margaret nodded. Every backup is digitally hashed when it's created. Within minutes, we were looking at a database snapshot from 5 months earlier. The amendment on the backup matched the original microfilm exactly. No expansion over my ranch. No fabricated owner consent. No forged boundary lines. Then we opened the current version. The differences were impossible to ignore. Someone had replaced entire pages. The metadata revealed something even more astonishing. The files hadn't been edited by accident. They had been overwritten using an administrator account at 2:17 a.m. on a Saturday. Daniel leaned back in his chair. Whoever did this thought nobody would ever compare the archived backup with the live database. Margaret quietly printed the audit log. At the bottom was a user ID, not a name, just an internal administrative credential. But it was enough. It can be traced, Daniel said. I nodded. And once it's traced, every document altered under that account becomes suspect. News travels fast in small communities. Too fast. By sunset, someone already knew we had uncovered something significant. As I turned onto Ridge Hollow Road, I saw flashing amber lights outside my property. 3 pickup trucks blocked my driveway. Several HOA board members stood beside a rented excavator. Victoria Langley was waiting with folded arms. Perfect timing, she said with a smile. What are you doing? She held up a bright orange notice. Emergency landscape enforcement. I looked past her. The excavator's bucket was positioned beside my grandfather's century-old oak tree, the tree that had stood there since before my father was born. You're not touching that tree. It violates our new entrance beautification plan. My property isn't part of your entrance. Rick Holloway climbed into the excavator's cab. We're improving neighborhood property values. I stepped directly in front of the machine. You'll have to drive through me. Victoria's smile disappeared. You really want to make a scene? You already have. Several neighbors had gathered across the road, phones raised, recording everything. Victoria noticed them and changed tactics. She raised her voice dramatically. Mr. Mercer refuses to comply with community improvements. One neighbor shouted back, "That's his land." Another added, "Show us the court order." Victoria ignored them. Instead, she nodded toward Rick. The excavator's engine roared to life. At that exact moment, Daniel pulled into the driveway. He stepped out holding a thick envelope. "Victoria," he called. She turned. "You've been served." A process server appeared from a second vehicle and handed her a federal complaint. She scanned the first page. Her confident expression cracked. "What is this?" "A lawsuit," Daniel answered. "No," she snapped. "I mean these agencies." She flipped through the caption again. Her hands began to shake. The complaint named not only the HOA, but also multiple unidentified co-conspirators involved in an alleged scheme to alter public land records, commit wire fraud, and interfere with property rights. Rick shut off the excavator. The crowd had gone completely silent. Victoria looked at me for a long moment. There was no smile now, only anger, only fear. "You have no idea who you're challenging," she whispered. I met her stare without blinking. I was about to say the same thing. 2 weeks later, After expedited motions and emergency discovery, we walked up the granite steps of the federal courthouse. Inside, a packed courtroom waited. For the first time since this nightmare began, every piece of evidence would be placed under oath, and someone was finally going to have to explain how my family's land had nearly vanished from the official record. The federal courthouse had never felt so different. I had spent more than a decade walking through its halls as a judge, entering through the private corridor reserved for the bench. This time I came through the public entrance like everyone else, passed through security, and took my seat beside Daniel at the plaintiff's table. Because I was personally involved in the case, I had immediately recused myself. The matter had been assigned to another United States District Judge, the Honorable Rebecca Holloway, a jurist known for her patience, meticulous attention to detail, and absolute intolerance for dishonesty in her courtroom. As she entered, everyone rose. "You may be seated." The room settled into an uneasy silence. On the opposite side sat Victoria Langley, Rick Holloway, the HOA's attorney, and 2 county officials. Their confidence from weeks earlier had vanished. Files covered their table, and they whispered constantly among themselves. Judge Holloway looked over her glasses. "Counsel, are we ready to proceed?" Daniel stood. "Yes, Your Honor." The defense attorney rose next. "We are." Daniel called Margaret Ellis as his first witness. She testified calmly, explaining how the county's recording system worked, how official filings were archived, and why the missing documents immediately concerned her. Then Daniel displayed 2 versions of the same subdivision amendment on the courtroom screens. One came from the official archive, the other came from the live county database. "They appear identical at first glance," Daniel said to the jury. "Would you explain the differences?" Margaret pointed to the enlarged images. "The survey lines have been redrawn. The owner consent page has been replaced. The notarization is different, and these signatures were never part of the original filing." The courtroom became noticeably quieter. The defense attorney stood for cross-examination. "Miss Ellis, isn't it possible these were simple clerical corrections?" "No." "Why not?" "Because clerical corrections don't replace recorded legal documents after they've been certified." He tried another angle. "Could the archive itself have been mistaken?" Margaret answered without hesitation. "No, the archive is immutable. That's precisely why it's maintained." The defense attorney sat down sooner than expected. It wasn't a good sign for his clients. Daniel's next witness was a digital forensics expert from the federal government. Using audit logs and server records, he walked the court through every electronic change made to the county database, every login, every overwrite, every deleted attachment. Finally, he enlarged a single page on the courtroom monitor. This administrative credential performed the alterations at 2:17 a.m. Daniel asked, "Were you able to determine who was using that account?" "Yes." The expert clicked to the next slide. A building access report appeared. Security badge records, computer login history, parking garage timestamps. The same individual appeared in every record. The county administrator. A murmur swept through the gallery. Victoria's attorney immediately objected. "Objection! This unfairly prejudices my client." Judge Holloway looked directly at him. "Overruled. The jury is entitled to hear the evidence." Daniel wasn't finished. He approached the witness stand carrying a sealed evidence envelope. "Your Honor, we'd like to admit Plaintiff's Exhibit 47. Proceed." Daniel removed several carefully reconstructed pieces of paper. The torn deed. The same one Victoria had ripped apart inside the county recorder's office. Each fragment had been professionally restored. He placed it beneath a document camera. The jury watched the torn edges appear on the courtroom screens. Daniel turned toward Victoria. "Mrs. Langley, you publicly claimed this deed was invalid before destroying it." She shifted uneasily. "Yes." Daniel held up another document. "Would you read the certification attached to the original deed?" She hesitated. Judge Holloway intervened. "Mrs. Langley, answer the question." Victoria reluctantly read aloud. "Certified original, verified, recorded, continuous chain of title." Her voice trailed off. Daniel nodded. "So at the exact moment you destroyed what you believed was the original deed," he paused, "you were also destroying the very document that disproved your entire claim." Victoria looked toward her attorney. He didn't look back. Then Daniel asked one final question. "Mrs. Langley, did anyone on the HOA board know the county records had been altered
before they demanded control of Mr. Mercer's property. Victoria opened her mouth, closed it, looked at the jury, then toward the county administrator. He subtly shook his head. Judge Holloway noticed. So did Daniel. And in that single, silent exchange, the entire courtroom sensed that the case had just taken an unexpected turn. Before Victoria could answer, the county administrator suddenly pushed back his chair and stood. "Your Honor," he said, his voice trembling, I need to correct part of the testimony." The courtroom froze. Judge Holloway leaned forward. "You may proceed." The administrator took a deep breath. What happened didn't start with the HOA. He looked directly at Victoria. It started with a developer. The jury stared. Victoria's face turned completely white. The verdict was now only hours away. But the biggest secret in the entire conspiracy had just begun to unravel. You could feel the atmosphere in the courtroom change. Up until that moment, the case had been about an overreaching HOA and falsified property records. Now it had become something much larger. Judge Rebecca Holloway looked directly at the county administrator. "Mr. Carlyle," she said calmly, "you are still under oath. If you intend to change your testimony, understand that every word you say carries legal consequences." "I understand, Your Honor." He took a slow breath and lowered his head. "It started 18 months ago." No one moved. The developer behind Willow Creek Estates wanted Mr. Mercer's ranch because it was the only parcel preventing a luxury waterfront expansion. They offered to buy it several times. He refused every offer. I remained silent. Every offer he mentioned had indeed been rejected. "The developer then approached me," Carlyle continued. "He said if the subdivision boundaries could be adjusted, they could pressure Mr. Mercer into selling." Daniel stood. "Who specifically approached you?" Carlyle looked toward the back of the courtroom. The developer, seated behind the defense table, suddenly looked away. "It was Charles Benton, president of Benton Land Development." Gasps filled the gallery. Carlyle continued. "He promised campaign donations, consulting work after my retirement, and $200,000. Judge Holloway's expression hardened. "And did you accept?" "Yes." The courtroom fell completely silent. "I authorized access to the recording database. I approved the replacement documents. I instructed employees not to question the changes." Victoria Langley closed her eyes. Her attorney slowly set down his pen. Daniel turned toward the jury. The HOA wasn't creating ownership. They were enforcing a fraud that had already been engineered. Then came the final blow. Federal agents entered the courtroom carrying sealed evidence boxes that had been approved for admission during a recess. Inside were financial records obtained through subpoenas, bank transfers, emails, text messages. One email projected onto the courtroom screen read, "Once Mercer believes he's trapped by HOA assessments, he'll eventually sell. Nobody fights forever." The sender was Charles Benton. The recipients included Carlyle and Victoria Langley. Victoria buried her face in her hands. There was nothing left to deny. After 2 days of deliberation, the jury returned. Everyone stood as the foreperson handed the verdict form to the clerk. My heartbeat was steady. Years on the bench had taught me never to predict a verdict before it was read. The jury finds in favor of the plaintiff on all civil claims. A quiet wave of relief washed over me. The clerk continued. The jury further finds that the defendants knowingly participated in fraudulent alteration of public land records, conspiracy, abuse of civil process, and intentional interference with lawful property rights. Judge Holloway thanked the jurors before delivering her own rulings. Every fraudulent amendment affecting my ranch was declared null and void. My property's title was reaffirmed exactly as it had existed for generations. The HOA was permanently barred from asserting authority over my land. The court awarded compensatory damages for the legal costs and harm caused, along with substantial punitive damages against the individuals found liable. Judge Holloway then referred the evidence of document fraud, bribery, and conspiracy to federal prosecutors for potential criminal proceedings. Outside the courthouse, reporters lined the steps. Microphones were everywhere. One journalist asked, "Judge Mercer, after everything that's happened, what are you feeling?" I looked back at the courthouse before answering. Relief, not because I won, because the truth did. Weeks later, Willow Creek Estates held an emergency meeting. The board resigned one member after another. Several homeowners who had trusted the leadership expressed anger after learning how they had been misled. The neighborhood eventually elected a completely new board, focused on transparency, instead of intimidation. As for my family's ranch, the old oak tree still stood at the entrance. Every morning when I walked past it, I thought about my grandfather. He used to tell me, land isn't valuable because of what you can build on it. It's valuable because of the promises you keep. For the first time in a long while, the ranch was quiet again, and this time, the silence felt like justice. It's been a little over a year since the verdict, and life has finally returned to the way I always hoped it would. The sunrise still spills across the eastern pasture every morning. The old barn still creaks in the wind. The century-old oak tree still stands proudly at the entrance, a reminder that some things are worth defending, no matter how powerful the people standing against you may seem. The legal battle changed more than my property. It reminded me that fraud doesn't survive forever when ordinary people refuse to look away and honest people are willing to speak the truth. Margaret risked her career to preserve public records. Deputy Brooks trusted his instincts instead of taking the easy path. Daniel never stopped digging until every piece of the puzzle fit together. Justice wasn't the result of one person. It was the result of people choosing integrity when it would have been easier to stay silent. If there's one lesson I hope you take from my story, it's this. Never let intimidation convince you to surrender what is rightfully yours. Whether it's your home, your reputation, or your principles, the truth is always worth defending. Thank you for spending your time with me and following this incredible journey from beginning to end. I truly appreciate every one of you who watched, listened, and believed that the truth would eventually prevail. Now I'd love to hear from you. Have you ever dealt with an HOA, a difficult neighbor, or someone who tried to abuse their authority? What happened, and how did you handle it? Share your experience in the comments. I read as many as I can. If you enjoyed this story, please like the video, subscribe to the channel, and turn on notifications so you never miss another gripping story of justice, property rights, and unforgettable courtroom battles. Until next time, remember, power can create fear, but truth has the power to outlast it.